5 people are facing terrorism-related charges. Prosecutors say that these 2 men, and quite a sight they are, were planning to make or use one or the other Molotov cocktails at the protest. And in a totally separate case, 3 others are accused of plotting to attack Chicago police stations, President Obama's Chicago campaign headquarters, and the mayor's home, plus several financial institutions. Their lawyer says undercover cops entrapped them by infiltrating the group and encouraging them to make the bombs. Our senior judicial analyst, Judge Andrew Napolitano, is here, and you know, that's entrapment, isn't it?
Well, it's the same MO over and over and over again. You find some dope or some psychopath or somebody totally disenchanted with society. You find a group of them, you infiltrate the group, and you persuade them to talk about engaging in acts of violence. Then you provide them with what they think is bomb-making materials. It's always inert. It's never a real bomb. They begin to assemble the stuff. They utter some incendiary language as they're doing so, and you arrest them. Except this time, all of that was done by federal agents who then withdrew from the scene. And this time, these defendants are being prosecuted by the state. This is not just an academic difference. The feds do not invest the time and money and resources in an undercover operation with sophisticated surveillance and then let local Chicago prosecutors and cops prosecute it. Question. Why would the feds leave the case? Because they probably don't think there's a case here. But the Chicago folks want to make a case out of it because they want to make an example out of these kids to deter other people from expressing their political opinions in the streets.
You've got to be kidding.
That's why it was so quiet when Steve Browns was showing the tape of them marching through the streets, because people are afraid to demonstrate. They were locked up last week. They're being held on $5 million bail, which is more bail required in Chicago than for murdering someone, all because they were picked by the feds to infiltrate, and then the feds left the scene.
How does this how do we have stories like this 2 or 3 times a week and no one in the nation seems to care?
Because the American public has been deluded into thinking that when the government finds a dope and persuades the dope to say bad things and think he's assembling a bomb, and then he eventually pleads guilty, somehow we are kept safe by that happening.
That's a load of it. Somehow we are made to feel like maybe they're doing something for us, and what they're really doing is trampling on our liberty.
Correct. Correct. They're picking the weakest among us, and talking them into thinking they are breaking the law. No harm, no bomb, nobody harmed, people locked up because of the words they articulated in front of a federal agent. But this case, I submit to you, is far worse. In this case, the feds themselves said, there's no case. We're washing our hands of it. And left it to the locals, who continued to prosecute. We'll see where it goes.
And locked them up in lieu of a bond higher than a murder suspect would get.
$5 million in cash. Normally, a bond of $5 million is a bond that you buy an insurance policy for $5 million. In this case, they want $5 million in cash. It would be impossible for these kids to come up with that.
Well, this is all very impressive. Judge, thank you.
Pleasure, Shep.
Unbelievable.
All right, the Supreme Court will consider shutting down a legal challenge to a law that lets the U.S. eavesdrop on overseas communication. But is this more hypocrisy from the Obama administration to try and keep the same monitoring freedom that President Bush was criticized for having? Joining us now is Fox News senior judicial analyst Judge Andrew Napolitano. Just break it down for us, Judge, real quickly. What is the issue?
In the Bush administration, Congress amended 2 laws, the Patriot Act and the Foreign Intelligence Security Act, commonly called FISA, which allows a federal court in Washington that meets in secret to authorize federal agents to listen to conversations of foreign nationals, whether they're in the United States or whether they're outside the United States. They listen to these conversations without any allegation against these people, even though the Fourth Amendment says there has to be probable cause for crime. So far, no problem. The problem is that some of these conversations are with Americans. So Americans are having the government wiretap their conversations without a search warrant consistent with the Fourth Amendment. So these people have sued.
Can I stop you here?
Sure.
The Americans are overseas.
No, that's the kicker. The Americans are in the United States. The FISA court has been authorizing conversations between between non-Americans overseas and Americans in the U.S. When this statute was up for enactment, when this amendment to the law was up, and a certain senator was the junior senator from Illinois, who now happens to be president, he railed against it. The government shouldn't have this power. The president shouldn't be doing it. Now that he's president of the United States, President Obama is 180 degrees from there. He's not only defending this action, he's saying it can't be challenged in court, and he's using it more often than President Bush did. It's another example of Barack Obama changing 180 degrees from when he was in the Senate criticizing a Republican incumbent in the White House to when he's in the White House and running the executive branch.
Judge, don't I want the FBI and the CIA to listen in on any conversation that they think is important to be listening into?
But you want a bar over which they have to jump, and that bar is in the Fourth Amendment to prevent the government from fishing expeditions, from listening to things that they shouldn't listen to. The government has to show probable cause. The statutes that President Obama voted against when he was a senator remove the probable cause requirement and allow the secret court, the FISA court, to authorize federal agents to listen to any conversation with any foreigner, even if one of the people on the conversation is an American in the United States.
Does there have to be a reason to listen in?
The reason is that the person is a foreigner. Now, the issue is, can this be challenged in court? Because the people who've challenged that are journalists, and the judge said, have you been listened in on? And they're going, we don't know. They don't tell you when we listen in. Is it probable that they're being listened into? Do they have the right to challenge this? All this will be decided by the Supreme Court.
Very good. Judge, thank you so much.
Pleasure, Eric.
All right.
Another big story today, the Archbishop of New York leading, or one of the leaders of a huge new challenge to the president's health care law. It's all over the contraception mandate. Timothy Cardinal Dolan saying this fight is going to court. Take a listen.
What the federal government did, unfortunately, and which got our Irish up, is when they said, and oh, by the way, we'll define what a church is. We'll tell you what you can and can't do. We'll set the parameters as to how you can minister, to whom you may minister, and the motives that should direct your ministry. That's the character, that's the tone of these straitjacketing exemptions. If our attorneys, who are very able people, said we need to take this as far as it can go, we'll be with them. We'll go.
Judge Andrew Napolitano is a Fox News senior judicial analyst and joining us now. Before we get to the nitty-gritty of this case, Judge, why now? Why do you think we're seeing these cases now in this time where the Supreme Court is just about to issue an opinion on the health care law overall? What do you think about that?
Because the Obama administration, which has discretion under the statute as to when certain parts of it will kick in, has decided that the mandate with respect to contraceptive provisions in health care will kick in. So if you are an employer and you provide health care coverage to your employees, that coverage has to consist of contraception, and you can't put that in overnight because you have to buy more coverage through the insurance carriers. So Cardinal Dolan, Father Jenkins, the president of the University of Notre Dame, and others similarly situated have to decide now what coverage will be available by the end of 2012.
So by filing these lawsuits, does that mean they don't have to go along with some of those requirements that are being asked to be implemented even now as the Supreme Court is trying to make this decision?
They would wish that that was the case, but the filing of the lawsuit does not exempt them from the requirements. It may get them an answer as to whether or not they have to comply with the requirements. Now, all of this could be moot if the Supreme Court invalidates the individual mandate.
So let's get to the issue of what these, the Archbishop, amongst others, are arguing. Tell us on both sides. Give us both sides.
Sure.
The best argument on both sides as to what the central issue is here.
The government's argument is that it is now the public policy of the United States of America that everybody be covered for all reasonable health care needs. And among those needs are contraceptive services, ordinarily provided to women, but they can be provided to men as well. And because the Congress has decided this is the public policy of the country, individuals can't exempt themselves from it. They had a chance to vote, and this is what Congress decided. That's the government's argument. Cardinal Dolan's argument, Father Jenkins, the president of the University of Notre Dame, argument is the First Amendment says the government can't interfere with the free exercise of religion. The Catholic Church has opposed non-natural birth control for over 400 years. In 1968, this was made a permanent teaching of the Catholic Church. This is a well-known teaching of the Church, and the government can't interfere with that free exercise. So if the government forces Catholic employers like the Archdiocese of New York or the University of Notre Dame to make available to their employees services that the church condemns, it would be forcing the church to violate its teachings, and the First Amendment insulates the church from that.
Does it have anything to do with the fact that these services, like the birth control pill, would have to be covered for free? If there was a fee attached to it in some way, would that change anything according to this mandate and the implementation from some of these organizations?
No, and in fact, the health care mandate, Obamacare, does not require that they be for free. It requires that they be available. So if your employer pays for your health care, the employer cannot add to your burden by adding this service to the health care. But if you pay for your health care out of a deduction, you could end up paying more if the insurance carrier wants more for this coverage.
So now that you've had almost 24 hours, not a long time, but a lot of cases here in front of you, Judge, when you see this argument, who do you think has the best argument? I mean, who would ultimately win here if it goes to court?
Well, we've never seen a challenge like this in court. We've seen other challenges where religious institutions have claimed exemption from the general law of the land. Probably one that comes to mind is the draft.
Okay.
People who were legitimately conscientious objectors. In some cases, some churches taught this, in some cases, individuals did. And in that case, the Supreme Court said, yes, if you hold this view in your heart with the same degree that one would hold a religious view, we're not going to force you to go into the draft. So if the Supreme Court looks to that precedent, which is around 1967, 1968, a Vietnam War era opinion, I think it will side with Cardinal Dolan. If it looks to a more draconian, whatever the government says is the law view, it'll side with the government. Prediction? Obamacare will be history before Cardinal Dolan's case reaches court, and he'll have nothing to worry about.
All right, you heard it here first. We'll see if you're right, Judge. Save the tape on that one. Thank you very much.
And I know you will, Jenna.
We will. You know I do. Hang on every word, Judge.
All right, so there is some new fallout this morning in the MF Global scandal. Documents show that former chief executive John Corzine got more than $8 million in cash and stock options in the months leading up to the collapse of this brokerage firm. Keep in mind, this is the 8th largest bankruptcy in the history of this country, folks. Now the company is still trying to trace $1.2 billion of client money that disappeared in all of this. So here's the question that's on a lot of folks' minds. Why hasn't Corzine or anyone else faced charges in this scandal yet? Who better to ask than Judge Andrew Napolitano, Fox News senior judicial analyst? You know, we get a lot of email about this. We see a lot of this in the social media. What's going on with John Corzine, and why is this investigation not underway?
This is Martha, the unfortunate intersection between government and politics, where the government has what's called prosecutorial discretion, a fancy phrase meaning it can decide who to investigate, who to prosecute, when to investigate, and when to prosecute. So it chooses to investigate J.P. Morgan Chase losing $2 billion of its own money, not clients' money and not taxpayers' money, within a week of the announcement of the loss. And it hasn't investigated Governor Corzine, former Governor Corzine's former company, MF Global, losing $1.2 billion of its clients' money, potentially commingling clients' money with the firm's money, potentially using clients' money to pay the firm's debt, and potentially denying what he knew about what he was supposed to have known about under oath. All of this saying, well, they must like John Corzine and not like his counterpart at J.P. Morgan Chase, Jamie Dimon.
That seems to be pretty clear. I mean, on the face of it, that is what it looks like. There's also the question of the CFTC, which apparently, according to some recent reports, Corzine personally lobbied to say, you know, that we could do internal repo, which means that when you need money, you can move that client money around. Personally lobbying the head of the CFTC and saying, you know, do not regulate us in this respect. We know what we're doing. We've got it all under control. That's the allegation in these reports.
All right. The CFTC, the Commodity Futures Trading Commission, is the regulator for the type of activity that MF Global engaged in. The head of the CFTC is a former protege of John Corzine when Governor Corzine was the chair of Goldman Sachs, Gary Gensler. Mr. Gensler has quite properly recused himself from this case, but yesterday spoke out publicly for the first time saying, I do know some things about what's going on, even though I've been remaining silent because of my prior relationship with Governor Corzine. You know what all of this spells? All of this spells need for special prosecutor, not connected to the Justice Department, not connected to the Democrats. Exactly.
And the possibility that the House Financial Services Committee is another arm that could be investigating this on their own, correct? And then we gotta go.
Yes, they can do it on their own, and they haven't.
All right, Judge, thank you. Great insight to that.
Welcome.
We appreciate it. Judge
My
Andrew
pleasure.
Napolitano. We'll see where that goes.
Facebook under fire. A group of shareholders suing the company and a handful of banks claiming it was misled about the company's finances ahead of the IPO. Do they have a case? To Fox senior judicial analyst Judge Andrew Napolitano. What's the latest?
Well, we talked about this morning, and since then another lawsuit has been filed. Right now we know of 3 lawsuits that have been filed. 2 against Facebook, one in California, one here in New York, basically alleging, as you've indicated, that they were materially misled by Facebook board and senior management and bankers and did not know what insiders knew. And they purport to sue in behalf of everybody who bought shares of stock. Stuart, you know how many shares were purchased? 421 million. We don't know how many human beings or entities own those shares, but these 2 plaintiffs in California and New York are asking a court, 2 different courts, to allow them to represent all the plaintiffs, all the shareholder owners. At the same time, a lawsuit has been commenced also in New York against NASDAQ by a plaintiff who says they wouldn't execute my shares on time. As I was asking them to sell, I was watching the value of the shares go down, and they wouldn't sell for me. And he purports to sue in behalf of everybody who lost because of NASDAQ.
Okay, so back to the basic lawsuit, which you think is going to be all amalgamated into one.
Yes.
NASDAQ gets sued because they messed up the trading system.
Right.
The banks get sued because they mispriced this offering.
Yes.
Facebook gets sued because they took too much money out of the system and withheld material information to small investors.
Those are the allegations.
And the plaintiffs here are the small investors who really did lose their shirts in this event.
Yes, because the big investors probably got out already. Goldman Sachs made $250 million in 2 days.
Goldman Sachs made $235 million profit selling their stake in Facebook.
Right.
And Morgan Stanley, the lead underwriter, the lead bank who brought this thing to market, they made $100 million reported.
Okay, here's the defect in the complaint, in the complaints. They are based on reports in the media because the lawyers for the plaintiffs have not yet seen the actual documents. The media has reported that Morgan Stanley discovered thus and so and didn't tell the investing public. It only told a select group of their clients.
Okay, so basically you're saying that at some point all of these lawsuits come together into one gigantic class action suit.
And if the court certifies the class, that is, allows these lawyers and these plaintiffs to represent everyone who was similarly situated, you will have the largest class action in the history of the world.
Can I get into it if I'm a small investor who bought the stock in the first couple of days on the market?
Well, yes, but before you ask if you can get into it, we need to know if there is a case. Well, and the case now is based on media reports.
Small investor out there is thinking, I lost my shirt, I want into the suit. Can they get in?
Absolutely.
Okay.
That's the purpose of the class action.
The end result.
I know you love this.
Know what's coming.
I know what's coming.
You know what's coming. Is it going to be, at the end of the day, the plaintiffs, the small investor, get a coupon to buy more Facebook shares and the lawyers walk away with the money? Cash, is that right?
That would be a ludicrous and absurd outcome, but not an unprecedented one. And surely we would hope, you and I, and those of us who believe in right and wrong and fairness, would expect an outcome in which those who really lost money got their money back.
Is it the rule of law or the rule of lawyers?
It should be the rule of law, Mr. Varney.
But it's not. All right. Thanks so much, Judge. It was a pleasure.
Pleasure, Stuart.
Today, the Senate launches an investigation into Facebook's multi-billion-dollar IPO from last Friday after allegations that select clients, high rollers perhaps, got inside information before shares went on sale. It's a big deal because the stock has tanked somewhat, and every day folks have lost, over the last week or so, lost a collective $2.5 billion. Here to weigh in is Fox News senior judicial analyst Judge Andrew Napolitano. All right, Judge. So, according to some news accounts, explain what happened.
According to some news accounts, Morgan Stanley, which was the lead bank on the underwriter, the person that
the middleman,
correct, examined Facebook's books and advised them how much stock they should sell and what the price should be.
So Facebook, we think your stock is worth X amount.
Right. According to the media now, that's all we have. Morgan Stanley gave Facebook a number which was far less than what Facebook told the public.
And it started selling at $38 a share.
Correct. We don't know what Morgan Stanley told Facebook. We don't even know if the story is true. But if it is true, that means that Facebook misled the public as to the value of the stock, and a lot of people lost a lot of money. So what do people do when they lose money? They've started to file lawsuits, and they're filing class actions, which mean one person is suing in behalf of everybody else. The everybody else is an enormous group. Facebook sold 421 million shares of stock on the first day. And this person suing says, I'm representing everybody that lost money because Facebook didn't tell us what Morgan Stanley told Facebook.
Well, Judge, here's what Morgan Stanley says regarding the IPO process. Morgan Stanley followed the same procedures for the Facebook offering that it follows for all IPOs. Those procedures are in compliance with all applicable regulations.
If the court allows this case to go forward, it would be the largest class action in history, meaning there'd be the largest group of plaintiffs and the largest group of defendants and the largest amount of money at stake in any litigation we have seen in the United States of America.
Oh, my goodness. And your advice for Mark Zuckerberg, if he's watching right now in his pajama hoodie.
Mr. Zuckerberg, don't spend it all. Put some of it in the bank. You might have to part with some of it.
Oh, my goodness.
If the media reports are true.
Right.
Discovery, the examination of documents by lawyers, will determine whether these media reports about Morgan Stanley are true.
Man, oh, man.
Business for lawyers, as Stuart Varney would say.
No wonder you're smiling. All right, Judge Andrew Napolitano, thank you, sir.
Pleasure, Steve.
All right.
Well, prosecutors can take a suspect back to court on criminal charges, including murder, even after the jury has rejected some of those charges. The Supreme Court made that decision today in a 6-3 vote. The case centered around a recent murder trial in Central Arkansas. The jury had announced it would not convict the defendant of murder, but it was deadlocked on lesser charges. The judge declared a mistrial. Today, Chief Justice John Roberts wrote that prosecutors can retry the defendant for murder. He said this did not amount to double jeopardy because the case never reached an official jury verdict before the mistrial. Justice Sonia Sotomayor wrote the dissent, arguing this would give prosecutors, quote, a second bite at the apple. Let's take it to our judge, Fox News senior judicial analyst, Judge Andrew Napolitano. Judge, great to see you, first of all. And secondly, do you think Sotomayor is right? Is this the second bite of the proverbial apple?
I do agree with Justice Sotomayor, and I think the legal community is going to be upset about this, and most Americans should be upset. This case was caused by a clerical error in which an Arkansas state judge forgot to reduce to writing in the form of an order that the jury acquitted this guy of capital murder, meaning murder with the death penalty. And because the judge made this mistake, the Supreme Court said there never was, as you said quite properly in your introduction, an official verdict, and therefore he could be retried. Trace, the whole purpose of the prohibition on double trials was to prevent this very thing from happening. A mistake allows somebody to be exposed to execution for a second time after a jury has already found him not guilty. This has never happened before in American history.
Let me give you some context to see if I've got this right, Judge. If we're talking about the George Zimmerman trial, okay, so George Zimmerman's charge was second-degree murder. If they found that he was not guilty of second-degree murder, but they were hung on the manslaughter, they could go back again and retry him for second-degree murder, is what you're saying.
If the same set of circumstances occurred here, the jury tells the court, we have found him not guilty, in your hypothetical of second-degree murder. The court forgets to put that down in a piece of paper, in a writing. And the Supreme Court interprets that forgetting as it was never an official verdict. Was he tried for murder? Yes. Did the jury unanimously find him not guilty? Yes. Therefore, he can't be tried over again. Except that today's case says he can. It's a radical change of 230 years of jurisprudence in this country. I'm disappointed and surprised by it.
Going forward, Judge, could this result in retrying cases that have already been settled?
No. I don't think that this would affect cases that have already been closed, but it could affect mistakes like this in the future.
And are you saying that in cases like this, Judge, that it's simply a clerical error, so you got to dot the I's and cross the T's and we're all fine? If you don't, then you've got a defendant that's in trouble.
Those of us who have done this for a living know that the moment the jury foreperson says not guilty, the defendant is acquitted. The reduction of it to writing is just form, it's not substance. But the Supreme Court has now said that's the linchpin to double jeopardy. If the judge doesn't write it down, you can be tried over again. That's wrong.
Judge Andrew Napolitano. Judge, great to see you. Thank you, sir.
Happy Memorial Day to you, Trace.
You too, Judge. Thank you.